The seller also provides under our contracts two other documents that are part of the disclosure. The first one is the property information sheet. In this property information sheet, it basically is a list of the different components of the property, and it requires the seller to tell the buyer of any defects that the seller is aware of in that part of the property. And it covers the equipment, the condition of equipment, soil problems, insurance claims, violations of any laws, any hazardous substance contamination, or any storage tanks that were on the property, any fire damage, any unrecorded title exceptions, and the leases. So this is the property information sheet. The second item that's required by our contract to be provided by a seller to a buyer is what's called the seller's mandatory disclosure statement. The seller's mandatory disclosure statement basically is to fulfill a seller's duty to disclose things that the law requires be disclosed by a seller to a buyer regarding whether or not the property is, for example, is in an earthquake zone or in a high fire risk zone or a flood zone. And it requires the buyer be provided a earthquake booklet and be notified if there was flood disaster insurance, and water heater bracing has been done if there's any mold, and there's a notification that's required to be given by law regarding title insurance. The seller's mandatory disclosure statement, as the name implies, is the seller's statutory duty. And a lot of this is taken care of by this cottage industry that's popped up many years ago, where natural hazard disclosure is provided by the seller as part of the seller's mandatory disclosure statement to the buyer. The property information sheet is meant to satisfy the seller's common law duty of disclosure of defects that are known to the seller that would affect the value or desirability of the property. So these two, combined with the seller's warranties, and there is some overlap between the information that's in the seller's property information sheet and the seller's warranties in the body of the contract. So a lot of people will add to the contract as is. And section 12.2 is the closest thing we have in the contract to, an as-is provision. Section 12.2 says that the buyer is buying the property in its existing condition and will have either done its investigations or waived those investigations that it thinks is necessary to protect itself. And the seller buyer acknowledges that there's no other promises besides what's in the contract. What does as is mean is, if you read the cases, they basically say that's supposed to alert a buyer that the buyer needs to do more diligent and thorough investigation. Commonly, there's a misunderstanding that, I'm not amongst the lawyers, but a lot of brokers think that if you sell something as is, you no longer have a duty to disclose the material bad facts, which is absolutely not the law. Even if you have an as is, you still have to, the seller still has the duty to disclose the bad facts to the buyer. So as a seller, you can expand the as is. And one of the most common ways that I've seen the as is expanded is for the seller to add a release of claims by the buyer against the seller for any claims that arise from the purchase and sale contract or the property itself. For example, the physical condition of the property's compliance with applicable laws, the property's any environmental problems. And that's often combined with a waiver of California Civil Code 1542, which I've seen more often than I would think would be acceptable in the market. But that's quite often I've seen the sellers are able to manage to get that, and it's often negotiated to push back on, obviously the law doesn't permit release of claims that are based on fraud and things of that nature, but you also carve out breach of seller's representations and warranties and covenants from these waivers. From the buyer's perspective, sometimes buyers try to beef up or strengthen the seller's warranties by asking seller to represent a warrant regarding the mechanical or physical defects in the property. For example, the building systems, that they're in good operating order. And usually the sellers resist this kind of warranty regarding matters that a buyer can discover by its own due diligence. And typically sellers are willing to warrant things that a buyer could not discover by its own independent investigation of the property, or going to the city, or doing whatever kind of due diligence that is necessary. So